Welcome back. You're watching To The Point. And now in part 2, my guest is the Law Minister, D.V. Sadananda Gowda. Minister, let's start with the National Judicial Appointments Commission, which, as you know, is presently under challenge in the Supreme Court. There is a learned and growing body of legal opinion that believes that in its present form, the NJEAC is likely to be struck down. How do you view that prospect?
See, I will tell you, appointment of judges, it is not the integral part of the judiciary. It is practically, it is an executive responsibility. So, executive has to do it. Even before 1993, you might have seen how it was functioning. Only after some judicial scrutiny, the court said that there should be a collegium.
That I understand, Minister, but there are two key concerns with the present architecture of the National Judicial Appointments Commission. I want to discuss those with you. First, by not giving judges primacy, there is a view that you have actually undermined the independence of the judiciary, and many people believe this is a key part of the basic structure of the Constitution.
No, I don't think so. The judiciary, their activities, their real work starts after the appointment, after sitting on the chair of that judge.
Except
till then, the appointment part will not. Judges should not appoint judges.
Judges should not appoint judges, but surely the level of political involvement in the appointing of judges should be minimal, because otherwise you'll undermine their independence. I'll tell you why I make this point. Justice Kehar himself has pointed out that you haven't given primacy to judges at best. Your architect gives them parity, which means that the 3 judges can be overruled by 2 out of the other 3 people.
See, I would like to tell you one thing. The matter is pending before the Supreme Court, so I don't want to go more inside the present issue, because it may amount sub judice. But I would like to tell you one thing. Now, the whole parliament, not only the persons or the ruling party, whole parliament unanimously accepted the people's mandate has to be respected. One, of course, I don't say that it should not be under judicial scrutiny. Yes, there should be a judicial scrutiny. For that reason, the things are going on before the Supreme Court.
But should you have judicial primacy? At the moment, the 3 judges are equal to the other 3. And since 2 people have a veto, 2 out of the other 3 can veto what the 3 judges want. In other words, the law minister and one eminent person can combine to veto what the 3 judges want. That's what the judges find difficult to accept.
For that reason only, it is 2 eminent persons have been should be there. That was the intention of the government. If 2 eminent persons, they will be persons of credibility. They will be persons who will be accepted by the people of the whole country. For that reason only, the 2 persons, eminent persons, will be selected by a team where it will be headed by the Prime Minister and the opposition leader, the single largest party.
So you see the 2 eminent persons as a safety mechanism, not as a danger to the primacy of the judges?
100%. What you said is 100% right, because the opposition leader plus the judge, the Chief Justice of India, who is presiding over the Judicial Appointment Committee, will be there in selection of 2 eminent personalities.
So the judges are wrong to look upon the 2 eminent as a body that can undermine the primacy of the judiciary. That is a mistake they are making.
I do concede, because this selection, if it is selected by only the Prime Minister or only by the ruling party, I would have considered with the view that has been advanced by you. But it is not like that. Here, the 2 eminent personalities selection will be done in such a transparent manner that the Chief Justice of India and the opposition leader will be the persons in that team.
In which case, Minister, let's talk a little bit about these 2 eminent persons, because that is in fact the second area where the present architecture of the NJEAC is being questioned. The first question is, these 2 eminent persons are chosen by a committee where politicians are in majority, not the judiciary. And people say, therefore, these 2 eminent persons will be politically acceptable, not perhaps judicially acceptable.
But the 2 political persons are in the loggerants now. They are not of the same team or same party. So neither the ruling party nor the opposition, they never used to come together at any point of time. You have seen since last 66 years.
That I accept from the point of view of a politician, but when you see it from the point of view of the judiciary believes politicians, whether they're opposition or government, often come together to check the judiciary. That's how the judges see it, that the leader of the opposition and the law minister, will combine to check the judiciary. You don't think that's a danger?
I want to go one step ahead. You see the constitution of the National Judicial Appointment Committee. There, 3 judges are there. If at all, we would have taken only 2 judges, then what argument made by you, it would have been right. I would have considered that.
You're not worried that the leader of the opposition and the law minister or the prime minister might combine to choose eminent persons who are tilted towards a political viewpoint rather than a judicial viewpoint?
I don't think, because law minister is not at all there.
The prime minister there.
The prime minister and the opposition leader and the chief justice of India.
And the opposition leader and the prime minister won't ever combine to check the judge?
Never in the history of democracy it has happened so far.
There's another concern about eminent persons. Sometimes these eminent persons could be lay persons. What assurance do you have that they will have the specialized knowledge to A, know who should become a judge, B, know how well that person is performing as a high court judge to justify becoming a Supreme Court judge, and C, be able to spot issues of corruption if it affects the judiciary? Will these lay persons have that knowledge?
I do concede this issue. The criteria, how and what are the eligible criteria of the persons who should be appointed as the eminent personalities, that is a question. That's a question that has to be decided by the 3-member committee. They should look into the matter. Nobody can say that that lay person or a person who is from judiciary, who is an academician, that should be appointed. But these 3 persons, and even while framing the rules and other things, we will see that the eminent personalities whom we are going to appoint, they should be above all doubts, all sorts of...
But you said a very important thing. You're saying that this 3-man committee comprising the Prime Minister, the Leader of the Opposition and the Chief Justice will first formulate criteria on the basis of which eminent persons will be chosen. That criteria will be critical. But that criteria still has to be formulated. It doesn't exist.
Certainly. I think that I don't want to enter inside the present arguments that is going on in the Supreme Court. But that will be one of the issues. That has got lit doubt in the mind of the people.
Now, another issue is that you have in your structure 2 eminent persons, but the Venkatachalaya committee only recommended 1. Why did you double from 1 to 2?
Sir, this is after a detailed debate on the parliament. The whole house, both the Rajya Sabha and Lok Sabha, all 100% of the parliamentarians, they said that this should be the criteria. That has been accepted, so it has been brought.
Now, one other question about the National Judicial Appointments Commission. There is a view that because the NJEAC Act was passed in August and the constitutional amendment only happened some 4.5 months later in December, the NJEAC Act could be invalid. To be absolutely safe, do you think you might have to pass it again a second time?
No, I don't think so, because of course there was a small delay in the sense
4.5 months.
Yes, small delay was there. The total thing is the rules and other things, as far as draft rules has to be framed, all other notification and other things need to be done. So this has taken certain time, but in spite of that, it is not an intentional delay for...
One other point about eminent persons, and I'm sorry to come back to it, but it's an important point. It's a point that was made in the court and it's been raised by the judges. One of the eminent persons has to be either a woman, a member of a minority, scheduled caste, scheduled tribe, or OBC. Why have you got reservations within the selection criteria for eminent persons? Surely that will weaken the NJEAC, not strengthen it.
I don't think so, because the whole constitution, we have gone as per the directives of the constitutions.
But you don't have reservations for judges, so why have reservations?
I do concede. As for the selection of the judges, who should be a judge, the selection of judges, there is no...
So then why for eminent persons?
But as far as, see, the representation should be given to each and every person across the country. That is democracy.
But then you may not necessarily have the best people. Reservations may ensure that to be able to guarantee you have a woman or an SC or an ST or a minority, it may not be the best available.
No, I don't think so, sir. In women or in SC or ST, there are persons who have got capacity, ability, who can tackle all the issues, who can select the right persons to that.
All right, let's move beyond the National Judicial Appointments Commission. I want to come now to something that you said on Monday in an interview to the Economic Times. You said that it was highly likely that the government might retain one of the clauses of the 2013 Land Acquisition Bill, and I'm talking about a clause which stipulates that if acquired land is not used within 5 years, it will revert back to the farmer unless we're talking about exceptional cases of long gestation like atomic plants. And what I want to ask you is this: was this just your loud thinking as law minister, or is this in fact the agreed position of the government?
See, this government doesn't have ego problems. Of course, we want to bring land acquisition and resettlement. That bill has to be brought into act. But at no point of time we said that it should be like this only. See, why we referred the matter to the Joint Parliamentary Committee? Because all persons will be there. Of course, there are certain provisions which we have taken away. That is one consent clause, and another is social impact assessment. The other areas, we never said that we will not do that. Because of the practical experience of 2013 Act, because of that, all the chief ministers across the state, they are the persons who are going to implement.
But you're saying a very important thing, Minister. You're saying to me in this answer that it is possible that you might retain the 5-year clause, with exception for long gestation projects like atomic plants. This particular clause could be retained.
No, say if the standing committee gives an opinion that this should be done, certainly we will not have any ego problems. We will certainly take the suggestions or the recommendations that will be given by the standing committee.
Now, this is the second time you use the phrase "you will not have ego problems." In fact, in your interview to the Economic Times, you said, and I'm quoting you, that we are not sitting on any ego issues. Whatever amendments the parliamentary committee suggests will be respected by us. Are you saying that there could be other suggestions, amendments from the Joint Parliamentary Committee which your government could be willing to accept?
No, I can't predict at this stage, but totally a farmer-friendly amendments have been brought. 9 amendments which altogether it has been accepted by the people of the country, that has been brought. Only because of the false propaganda and because there is a political, somebody wants to gain some political mileage.
Can I interrupt?
Yes,
you're
sir.
saying you're open to farmer-friendly amendments.
Yes.
Would you be open to a farmer-friendly amendment which dilutes the consent clause from the 80% at the moment to just 51%? Could you accept a 51% consent clause, which, by the way, is something one of your allies, the Shiromani Akali Dal, has been suggesting? Could you accept this?
See, if after the discussion in the Joint Parliamentary Committee, if there is a consensus and an opinion comes, certainly we will look into the matter. Certainly we will look into the matter.
This is a very important answer you've given. You said you're prepared to look into this matter and accept possibly a 51% consent clause.
Sir, the percentage will, it was reduced from 80 to 70% in our amendment and all that. And practically national strategic projects which really requires more than 5 years and all that, certainly those has to be exempted, otherwise it could not be done.
But for other things, 51% as a consent clause could be considered.
We can consider. We can consider.
That's a very important thing you're saying. Now, on repeated occasions, the BJP has said that nothing that you are proposing as amendments to the land acquisition bill is going to specifically help industry. But can you deny that land acquired for PPP projects and land in industrial corridors will directly help industry?
See, two things has to be taken into consideration while while answering this issue. One is with regard to the farmer and the person who loses his land. The other one is the development of the country. The development of the country also looked into the same manner.
Absolutely.
Because I think that you do agree that farm sector cannot generate so many employments as it will be
Minister,
generated
your
by
argument
industry.
I fully accept. All I'm saying to you is that when you talk about development of the country, you're talking about industry, and when you talk about industry, these acquisitions will help industry. How can they not? If they don't help industry, there's no point to them. Therefore, I can't understand why BJP says these acquisitions won't help industry. They have to help industry. That's the reason you're doing it.
See, I will tell you, if an industry comes into a remote corner of the village, what will happen? What will happen? We will get more connectivity. We will have get better roads. We will have get better electricity.
You're answering my question for me. You're answering my question for me. Yes. Clearly, your land acquisition amendments are designed to help industry. The rhetoric which claims they are not is just for
it is
public
not
consumption.
No, it is not true. We have been branded as a corporate friendly.
That's the problem. No, that's what you're trying to escape from.
That false propaganda has taken one step ahead. We were not able to see that false propaganda is not true, that we could not able to
I'm not talking about the false propaganda. Let's leave that aside. I want to ask you a critical question. Who will own the land in industrial corridors?
Sir, there are so many things, sir. Industrial corridors, of course, the industrialist, the investor, he will have priority all.
But so in industrial corridors, industrialists and investors will own the land.
Yes, certainly, because the person who loses the land, we will have an appointment, and his family members will get an appointment.
Absolutely. Yes. The person who loses the land will get a job, his family members will get a job, but the land in industrial corridors will be owned by industrialists and investors. That's what you said.
Yes.
Let's then come to two small but critical questions. Are you confident that the parliamentary committee that's looking into the land acquisition amendments will meet its schedule? Because now newspaper reports are suggesting that there's pressure to try and meet all the state governments to get their views, and that suggests that they won't meet their deadline of the first day of the monsoon session. Are you worried it could get delayed, it could get pushed back?
I can't say how when the parliamentary standing, but the implementation of all land acquisitions has to be done by the state government. That is one of the areas that we should look into.
That I understand.
For that reason only we are, even earlier also, when Nitin Gadkari was the concerned minister, he took the suggestions of all the chief ministers, and then we went ahead. The earlier act, 2013 act, everybody said, right from the chief minister of Kerala, then your Maharashtra, even...
I'll tell you why I asked this question. You see, members of the parliamentary committee are putting pressure on Mr. Ahluwalia that they want to consult all the state governments. Mr. Ahluwalia has reportedly, according to the papers, written to the speaker to get permission. Yes. In the meantime, the Congress chief ministers passed a resolution yesterday to say that they are completely against the land amendments. Now, the point I'm making is this: if you have to consult all the state governments, it's very likely the committee won't meet its deadline of the first day of the monsoon session. Does it worry you that the report could get pushed back? It could get pushed back by weeks.
I would like to tell you one thing. The Congress people who just that 5 members, they had their meeting yesterday. They ought not to have their meetings there. They ought to have suggested everything in the parliamentary standing committee only. When they are the members, why they should have separate meeting outside? They are at liberty to say everything on the parliamentary standing committee. It will go on record, and finally addition will come.
But the reason I ask is because they are clearly playing politics. They are trying to find ways or excuses of delaying the report. And I'm asking you this: are you confident you'll get the report on the first day of the monsoon session, or do you think it will fall back by weeks, maybe even a month?
I am not in a position to say how the chairman of the committee will take this issue.
It all depends upon the chairman
of the committee.
Most people say that when it comes to a vote, you're likely to lose in the Rajya Sabha because you don't have the numbers. Will you then push these amendments to a joint sitting?
See, we ought to have done it earlier, but we never wanted to do it, because there should be a consensus, because all the states, various states, there are about 7 or 8 states where Congress chief ministers are there. So the implementation in those states, see, we have given an option, sir, 1 minute. We have given an option. If any state, if they don't agree with this, our bill of 2000,
they don't have to implement it.
No, not necessarily. Earlier act, they can opt the earlier act.
You began your answer very nicely. You began by saying we ought to have done it earlier. Yes. Are you saying you ought to have taken this to a joint sitting of Parliament earlier?
We would have taken, but for that only I used that ego problem. You don't have that ego problem. You want to have a consensus.
But now, if it fails in the Rajya Sabha, despite all the efforts you made, will you now then go to the joint sitting? Will you now do that?
No, I don't think that it will go to that extent. I hope that it will be resolved earlier by getting a report from the standing committee, joint parliamentary standing
But
committee.
if it's not resolved at the Rajya Sabha
I
level,
hope that we are certainly.
but are you
I am
prepared to go?
optimistic.
But are you prepared to go to a joint sitting if you have to? That's what I'm asking.
No,
Are you
in the
prepared to
larger
go?
interest of the country, if that requires, then we have to think of the matter at the particular
In
situation.
the larger interest of the country, if that's required, you will do it.
No, if necessary, if in the larger interest of the country, if it is necessary, we will do it.
Okay, that's very clear. If it is necessary in the larger interest, you will do it. Let's now come to a third subject. Your government has been in power for 1 year, just over 1 year. But you haven't as yet found 2 members of the Anglo-Indian community to nominate as MPs to the Lok Sabha, which the constitution permits you to do. 20% of this parliament is over and you still haven't done this. Why?
This is a matter that has to be looked into by the Honorable Prime Minister. I am not in a position to answer this.
Let me put it like this. Does your government believe that special nominations for Anglo-Indians is not necessary because there is adequate representation for Anglo-Indians in the Lok Sabha as it exists at the moment? Is that why you
Sir,
haven't done it?
I will tell you one thing, sir. No nominations, not only for that, even for some other purpose also not been done, because we were in the membership drive since last 1 year. After the completion of the membership drive, now we have reached about 11 crore members for the party. Once the membership drive is over, then we will identify the persons who should be
Minister,
placed in which
are you
places.
really seriously saying to me that the membership drive of the BJP took priority and precedence over the need to appoint 2 Anglo-Indians to the Lok Sabha? One is almost a constitutional requirement. The other is simply a party matter.
No, but both should be tied up together. See, when there is an absolute majority for this party, the party also need to be consulted when the appointments of some 2 Anglo-Indians are done.
Let me put it like this. Almost 6 months have passed since Charles Dias, the president of the Federation of Anglo-Indian Associations in India, wrote to the Prime Minister in December, pleading with him to nominate 2 Anglo-Indians to the Lok Sabha. He said that this is a community that lives in poor conditions, they need help, they therefore need these MPs.
No, I am not aware of any letters that has been written by the chairman or that community. I am not aware of all those things, so I am not in a position to answer this.
Okay, but one last question on this. Can you give me any sense of how much more time it will take before you nominate these 2 Anglo-Indian members to the Lok Sabha? Are we talking about weeks, months, or are you going to take another year?
But it is the prerogative of the Prime Minister. He has to do it.
It's
So,
entirely in his hands.
yes.
So this is a decision only he can take, no one
Yes.
else.
Yes, he has to take.
All right. Let's then come to something else. I want to come to Article 370. It's a manifesto commitment of the BJP. But when you signed your agenda for alliance with the PDP, this is what you said in that agenda. The present position will be maintained on all the constitutional provisions pertaining to J&K, including the special status in the Constitution of India. So does that mean that as long as the BJP-PDP alliance in Jammu and Kashmir lasts, and it could last for 6 years till 2021, you will not make any attempt to abrogate Article 370?
No, I made it very clear on the floor of the House in the Rajya Sabha. I said that it needs wider consultation. After due consultation with all the political parties, all the persons or stakeholders, then only we have to come to a consensus has to be formed. This is not a Article 370 where, of course, it is in our manifesto. We have a promise to the people, and not only that, even Ram Mandir, Article 370 and all those things, it needs to be wider consultation and a consensus has to be drawn. Then only we should go ahead.
I am grateful for what you are saying, that you need a wider consultation, and B, you need a consensus after that consultation. But I am asking a very specific technical point. You see, you can have consensus and you can achieve consultation within 2 years and 3 years. But the stipulation of your agenda for alliance with the PDP says that during the duration of that government, you will not abrogate. So what I'm saying is, are you saying to me that for 6 years, assuming that government in Jammu and Kashmir lasts 6 years, there will be no abrogation of Article 370.
No, if we are able to convince the Honorable Chief Minister, who is a alliance partner of us, within 1 year, we could be able to go ahead with this.
Absolutely. There's another way of reading that answer. The Honorable Chief Minister, Mr. Mufti Muhammad Said, has a veto as well on this subject, because if you can't convince him, you can't go any further. That is an implication of your answer.
Yes, certainly, because I said that there should be a wider consultation and consensus. So, if we should be able to convince him in the larger interest of the country to have a unity and to have
absolutely. And if you can't convince him, you can't go further.
That all these hypothetical questions I can't answer, because
you did a moment ago.
I will tell you. We are very positive in our approach, and we have got a certain what you call that credibility that we will go ahead and we will able to see that we will convince him.
Well, that's what you think. Maybe you will succeed. Chances are you probably won't. Let me come to my very last question. How do you respond to the All India Muslim Personal Law Board stand that it is unconstitutional for government schools in India to teach yoga, and in particular Surya Namaskar is something that is offensive to Islam? How do you respond to that?
This is a very sensitive issue, because everybody doesn't say that Surya Namaskara is a religious activity, but there are certain persons, each and every in area, there are few persons who will find fault with certain things. So I don't think that Surya Namaskara is causing any injury to any of the communities, but I don't know the views of the persons who said that Surya Namaskara is against the religious activities of that community, but I don't think so.
Are you saying that you therefore dismiss the views of the All India Muslim Personal Law Board?
No, it should not be. It should not be. Because
it should not be dismissed?
It should not be dismissed at this stage, because...
So you will pay careful attention?
Yeah, we should have a careful attention to this, because whenever certain issues which needs to have a solution after consultation and all that, if we are able to convince those people, Surya Namaskara is not like that. It is not...
what about teaching yoga in schools? They don't think government schools should be teaching yoga.
I think that yoga should be taught in schools.
So here you disagree with them?
That also, after consulting with those persons, we should convince them. See, by doing yoga,
so
these are things...
Your stress is on persuading and convincing.
Yes, persuading and convincing is the
not coercing.
Yes, no.
Minister, a pleasure talking to you.